It says certificate of service was served on the district attorney's office. 5 CR 951 and 952, Moses Green Sr. You were charged in 25 CR 951 with the first degree felony of aggravated sexual assault of a child younger than 14 years of age, but paragraphs 2 and 3 reflect that the defendant has two prior burglaries of habitation convictions out of the 252nd District Court. If found guilty of this first degree felony, and if the prior convictions were shown, you were looking at a minimum of 15 years in prison up to life imprisonment. Do you understand on that case? Yes.
Yes, Your Honor.
25 CR 952, you were charged with the second degree felony of sexual assault of a child. Is it the same before? Because the different names, but the first names are the same. There's the surnames are different. Is it the same child?
I believe it's the same child.
Yes.
Judge.
Yes.
Playing catch up, chasing paper.
Judge, to be fair, I don't see either Mr. Ham or Ms. Monk on the service contact list. So it looks like it may not have been provided. Usually it goes to one, the other, or both.
Nonetheless, this bar is here. This second case, 952, alleges a second degree felony of sexual assault of a child younger than 17 years of age. And the same two prior convictions of burglaries are included. So this, if all of this was found true, you're looking at first degree felony punishment in this case of no less than 5, no more than life imprisonment. So
Can I say?
2 life.
I'm sorry, John.
When you 2 life imprisonments are what you're looking at. What are his bonds right now?
So my understanding is that one is at 300,000, Judge. This is kind of strange. I can't see him on the inmate list. So, and I can't see an amount in the portal.
It's 300,000 on 951 and 200,000 on 952.
And so we're requesting reductions to 100,000 apiece, Judge.
Okay. Say.
Judge, I feel like the amount that's set on this with his criminal history and the nature of these offenses is certainly reflective of what I've seen on bonds of these kind of cases. I would stand by with the safety of the community that the bond amounts are appropriate.
The court is looking at the circumstances of these cases. I've read the probable cause affidavits.
On the circumstance, on the circumstance matter, may we address
Oh,
one?
hold on. I'm just making I'm just telling it, setting forth the record. The court has reviewed the probable cause affidavits, the public safety report of the defendant, which reflects a rich criminal history that is not included in the indictments, dating back to 2001, when the defendant would have been 14 years of age. Then that's odd. He was placed on probation for a year in 2001 for theft. Then 3 years later, just a little over 3 years, he's convicted of burglary of the habitation. Two burglaries of the habitation. 2005. Then it shows burglary of a building, convicted, 1 year confinement.
No felony conviction, Judge.
And then possession of marijuana, convicted. Driving while intoxicated, Class B conviction. Assault family member, 2010, convicted, 30 days. Assault family violence, 30 days, conviction, class misdemeanor. Then criminal trespass, convicted, 10 days. Misdemeanor, evading arrest or detention in 2013, 60 days confined. Failing, giving false information to officials, convicted. Assault of a probation, 10 years. Probation in 2013, and that expired. Evading arrest or detention in 2013, 60 days confinement. Resisting arrest in 2013, 60 days confinement. Failing to ID, the same kind of crimes that we're looking at a few years before. Then assault on a public servant, deferred, third-degree felony, 2013. And then reckless driving. So I'm looking at 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18 dispositions of probation or confinement of offenses of felonies and misdemeanors. And then now these 2 new cases have occurred. Anything else anybody wants to add?
Judge, on the indictment for the aggravated sexual assault of a child, December 31st of 2015 is listed as the date. And while the law certainly does not require the date to be exact, I did want to bring it to the court's attention that in October of 2015, on his probation, a warrant was issued. He went into custody shortly thereafter and was in custody. He went from custody to safety. The court ordered him to serve in conjunction with that arrest a period of upfront confinement, and then he went to a substance abuse felony punishment facility, and he participated in the special needs continuum of care from January 8th of 2016 to September 27th of 2017. And so as far as the way the indictment is worded, obviously the defendant's position is that it wasn't possible for the offense to have been committed on or about the date listed. I think the court, in conjunction with the request for the bond reduction, if court could just explain that aspect of the indictment, I believe.
I don't know. How can I explain that? I didn't write it.
When I say that aspect of the indictment, I mean the law as it pertains to the specificity of the date in the indictment and how.
The law does not require, but I think all the lawyers here know that. Yeah. And Mr. Wilkerson knows that. He deals with this all the time. The law provides that crimes can be alleged on or about a certain date, and on or about is a reasonable length of time. But generally, on or about has been by case decision to go back as far as up to the statute of limitations. So in a case like this is unlimited statute of limitations. So on or about probably has little meaning on this in these circumstances. So, but I have looked at the defendant's rich criminal history, probable cause affidavits in each of these cases, public safety report. This is a most disturbing set of circumstances of the victimization of a child and if, your request for reduction of bond is, well presented but denied, this is set for trial and we're fast tracking this. When can y'all be ready? It's got my attention. Whenever I know you're in trial, I'm not talking about the day or the next day, but can we set it in 3 months?
That would work, Judge. I would like the opportunity
But
to,
especially said, go ahead.
I like to build a relationship with a child before they testify. So 3 months should work for me.
Specially sent for them. That is all. Anything else? We're in recess. Let's get ready for trial.